Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. So we received an interesting inquiry here on our YouTube channel. This has to do with domestic violence and assault of a minor. Let's see here. One night I argued with my wife. She began to hit me. To calm her down, I grabbed her by the neck. My 5-year-old son hit me in the back with a broom. I took it, then swung it at him and broke his little hand. Oh God, I was arrested. Oh jeez. Well, first of all, if your wife is in process of hitting you, you can use physical force to just grab her hands to protect yourself. That's okay. That's self-defense. Now, if she's hitting you with her hands and you decide to grab her by the neck and you start squeezing, that's going too far. Because you can only use the minimum force necessary, to avoid suffering bodily harm yourself. But once you get to a point where now you're being the new aggressor and you're doing something absolutely horrific to her, well then now you're not going to be just charged with domestic violence as she will be, but you're going to be charged with a felony of assault with brute force. And depending on how much you squeezed and how long you squeezed, you can even be charged with an attempted murder under Penal Code Section 187/664, which carries up to life in prison, 25 to life. Now, the other issue is that we have here is the child. I mean, a little 5-year-old hitting you with a broom. I mean, you're not in any danger there. I mean, what are you really defending yourself from? Take the broom and that's it. You take the broom and then you start swinging it at him at full force with definitely enough force to break his hand. Well, that's going to be child abuse. That's going to be a violation of Penal Code Section 273D. That's a felony that carries up to 6 years state prison here in the state of California. Not only that, but there's going to be a GBI clause, a great bodily injury clause. You broke his hand, so that's going to potentially increase that punishment an additional 3 years. So yeah, that doesn't fly very well. Doesn't sound like the type of case you'd want to take to jury trial. Definitely does not sound like the type of case you'd want to take to jury trial. The jury hears that you broke a 5-year-old's hand after trying to choke your wife because she swung at you a few times. Yeah, that's not going to be so favorable. You might want to talk to your attorney about cutting a deal to resolve this case, but jury trial is probably not a good idea here. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comments section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need a representation, give us a call for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we are going to be discussing the case of somebody who received a call to participate in a jury, but he has a criminal record. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.